you, and good morning, everybody. It is Friday, the 11th of June, 2021. We're broadcasting live. This is a licensing subcommittee meeting of the Royal Borough of Kensington and Chelsea, meeting to decide the application from UKI of 240 Portobello Road, London W11 1LL. My name's Greg Hammond. I'm councillor for Courtfield Ward in South Kensington. I have no interest to declare, but I am familiar with the site. And my final panellist today, I will ask her to introduce herself.
Thank you, Chair. Good morning, everyone. I'm Councillor Pat Healy. I represent Dalgarno Ward and I have no interest in this application.
Thanks very much. And the pair of us are the decision makers in the case, and we are quorate with a subcommittee of two of us. We're assisted by a number of other parties in the room, so starting with the legal officer, please.
Good morning, Chair. I'm present.
Thank you, and that's Heidi Tickham, I understand. And we have licensing officers. If you'd like to introduce yourselves, please.
Good morning, Chair. Paul Phelan, present.
Thanks, and I understand Melanie Adams with you, just helping out with documentation.
Yes, good morning, Chair, present.
Thanks very much. And we do have a number of governance officers with us helping with the technicalities of the meeting. I won't introduce them all, but they may appear online. So it's Anne, Esme, Hannah, Tom and Gareth are the ones I'm expecting. And for the applicant, I understand, Mr. Cannon, you're online. Would you like to introduce yourself and your party, please?
Yes, good morning, sir. Good morning, councillors. My name is Joseph Cannon, council representing Freshly Made Limited, who's the applicant for this licence. I've got with me Amir Mervan, who's the director of that company, and also Marcus Lavelle, who instructs me.
Thanks very much, Mr. Cannon. We don't have, apart from licensing, we don't have responsible authorities present. We don't have the single objector either, but the committee members will ask questions to ensure a fair hearing. Ground rules for doing an online hearing: please only unmute your microphones when you're called to speak to prevent any background noise. Please also turn off your cameras to save bandwidth, except when you've got a speaking part. And please do not use the chat function on Microsoft Teams because it's not monitored. And so if we could mute the microphones, please, because I was getting some background noise from somebody there. And finally, I'd ask people to speak slowly and clearly when because the panel members, are taking notes. We've had a couple of documents before the hearing. So the first one is the main committee bundle. That's 88 pages, and we'll call that one Exhibit 1. We had an additional bundle from the applicant on Tuesday. That was 15 pages, and that's Exhibit 2. Panel has read everything in the document, so there's no need to repeat the content, but please do draw our attention to relevant parts of it as you make your cases. The outline for the day, in a moment I'll ask the licensing officer to give an outline of the case. The applicant will then get 10 minutes to present the case, and it'll be followed by a question from the members and the legal authority, the legal officer, and then we'll have a discussion on potential conditions, and there won't be a summing up, and that will be the end of the proceeding. Are there any preliminary matters before we get started here from Mr. Cannon?
No, thank you, sir.
Okay, in which case, Mr. Phelan, would you be kind enough to give an outline of the case, please?
Thank you, Chair. Good morning, everyone. Today's application has been submitted by Freshly Made Limited for the grant of a premises licence at UKI 240 Portobello Road, London, W11 1LL. Today's application is for the grant of a shadow premises licence, which seeks the exact same terms as those currently permitted on licence number 911902. A table confirming the precise timing sought for licensable activities has been included at pages 1 and 2 of today's papers. A full copy of the premises licence 911902 can be found at Appendix A, pages 28 to 37, with a copy of the current applications shown at Appendix B, pages 38 to 54. This application did not attract a representation from responsible authorities. One representation has been received which opposes this application. A summary of the representation can be found on page 5, with a copy attached at Appendix D on pages 55. Council records indicate that within the preceding 24-month period, 31 complaints and 4 temporary event notices have been received for this premises. A summary of each 10 has been included at Appendix E, page 56. A list of complaints has been included as additional papers, and this document was circulated to relevant parties on the 27th of May 2021. That concludes the summary of this application. I'll leave it there for now. Thank you.
Thank you very much. Just to clarify, Mr. Phelan, that the item that you said was circulated on the 27th of May, is that included within the main? That's not included within the main bundle, is it?
It was sent separately from the main bundle. So the main bundle was dispatched, I believe, on the 26th, and the additional document was dispatched on the 27th. And it's a schedule of complaints over the preceding 24 months.
Right, I've got a schedule of complaints within the. Okay, maybe that's been attached to the end of my hard copy here. I've got a schedule of complaints which starts 1st of June 2019 and ends, the last one's on the 15th of May 2021. Mr. Phelan, is that correct? It's 3 pages. Sorry, it's 4. Yeah, 3 pages.
3 pages, as you say. Started on the 1st of June and finished on the 15th of May 2021.
All right. Well, for me, that's part of Exhibit 1. It's part of the 88 pages because I've got it in hard copy.
Understood. Thank you, Chair.
OK, thanks, Mr. Phelan, for clarifying that. Mr. Cannon, would you like to outline your case, please?
Thank you, sir, and thank you for clearing up that 88 or 85 page issue. My main bundle is 85 pages long, but with the 3 pages of the additional document, that's your 88. So I think we're working from the same document. So I'm going to just deal with 3 headlines. First of all, a background to the application, why it's being made. Secondly, dealing with the objection. And thirdly, just talking to the conditions that are being proposed. So I'll start with the background. Freshly Made Limited are the head leaseholder of 240 Portobello Road. They took a lease from the freeholder in 2015 and invested pretty heavily in what was then a derelict building, essentially, and made it into the premises that it is today. It has, in turn, sublet the building to Mr. Veros, who's the premises license holder and who runs Ukai, which is a Japanese, largely sushi-led restaurant and bar with a sort of live music theme. Mr. Veros has a premises license, operates it, and you may be aware, was the subject of a review in the autumn. It was in October, a review brought by the objector who objects today, and his partner. And at that review, there was an extensive and lengthy hearing about what should be done about that premises license, and the decision, which was finally published on the 13th of January of this year, imposed a series of conditions and permitted that license to continue under those conditions. Now, I want to be absolutely clear, this application today for what's called in the vernacular a shadow license replicates exactly the conditions that the subcommittee thought were appropriate on the 13th of January 2021. There's no difference at all. The only difference is that this is a license to be held by the, if you like, the head lessee rather than Mr. Veros. It's a shadow license. The idea being, as foreshadowed in Kensington and Chelsea's licensing policy, which is in your bundle, the idea being that if, for whatever reason, and we have no reason to think it would, but if Mr. Veros became incapacitated, heaven forfend died, then the license would lapse, and Freshly Made and Mr. Mervyn, as the director of that company, would like to have some protection in order to be able to continue trading. Of course, licenses lapse on incapacity, death, insolvency of license holders. So it's a protective application taken from a point of view of business efficacy, nothing more. And it's not expected that this license will need to be operated unless the unthinkable happened to Mr. Veros. But it's really from a business efficacy point of view that the application is being made. As I say, the conditions that are proposed are exactly the same as the conditions on the main license, if we can put it that way. And those conditions were, if you like, the final settled view of the subcommittee, having heard evidence in detail from a number of objectors or people making representations in the review held in October and decided in January. Now, that's important because I'm going to come to the objections now. There is only one objection today, and that's from the neighbour, Mr. Joel Thomas. That neighbour lives directly opposite Ukai, across the street, and has recently, and we understand without planning permission, relatively recently installed an outdoor roof terrace from which they overlook Ukai. And it seems to be that the complaints come from their use of that unauthorised outside area. Now, that's not a matter for today, but that is a fact of in the background of Ukai. What is important is to note that of all those complaints in the schedule, no objection by me for those being considered, but the vast majority of those, of course, occurred before the review, which was on the 1st of October. So it's really only the last page, and even then only 3 or 4 on the last page, I think 5, that post-date the review. So all of those complaints were already taken into account and considered at the review, and the decision on review took into account the findings on those complaints. So that leaves just, I think, in fairness, 1, 2, 3, 4, 5. So I'm looking at the 3rd page, so probably your page 88. And you can see that one of them, 19th of April 2021, is a complaint of tables and chairs outside, something that is entirely legitimate and pursuant to a table and chairs licence that had been granted the day before. So that's not a legitimate complaint, but is an indication of how this particular neighbour deals with Ukai's activities. And then again on the 9th of May, there's a complaint of loud outdoor dining. Again, the outdoor dining element, entirely legitimate. The loudness is not accepted. You can see that Environmental Health have not seen fit to make an objection today. And in fact, the reality of the world at the moment, because of the ongoing COVID restrictions, is that outdoor dining is just what's happening. It does create a little bit more noise than indoor dining if you live directly opposite, and that, I'm afraid, is something we can't get away from. We thought it might be useful to put in some photographs, and you've seen those, of lots of premises in the area which also have tables and chairs licenses, lots of outdoor dining, and there's a couple of photos of Ukai there too. Our outdoor experience is a sit-down, meal-led dining experience, and in fact the complaints seem to bear that out. Without wanting to say too much in the objector's absence, it is fair to observe that they are keen to make life difficult for Ukai as much as possible, but they haven't thought fit to turn up today, so we're not able to understand the reference to forcibly entering their premises when that was. We don't recognise that at all. Don't know what that was. And in terms of the complaint about our management structure, or however it's put, I've made that clear. I hope there's nothing hidden here. There's a freeholder of the building, as is perfectly normal. Freshly Made is the head lessee, and it grants a sublease to Mr. Veros, who runs Ukai. This application is to protect Freshly Made, as I've already said, in the event that Mr. Veros is incapacitated, or indeed that the licence is revoked, which takes me neatly, I hope, to the question of conditions. Now, very grateful as usual for the list of suggested conditions that's been circulated. I just want to make a couple of points about them. First of all, the list of the first section, the conditions, which says that it is consistent with the application, that's correct. Those are all the conditions on the present licence held by Mr. Veros, just replicated for this one. And of course, we absolutely accept that they should be imposed. There are then 2 suggested conditions that on the schedule, there's a suggestion that those were put forward by the objector, but that's wrong. They were put forward by us. So if whoever's in charge of the screen could just scroll down, all of these conditions offered by the applicant are just a straight replication of the existing Ukai licence. More than happy for you to go through those at leisure, but they don't add very much given that they're just replications. I'll just wait for the screen to get down to the next section of conditions.
I think it's 26 and 27 we're looking for, so if we could scroll quickly to them, please.
I'll try not to get anxious about my 10-minute time limit while this is going on. I think probably the computer's next.
As we don't have another party, I'm not going to be precious about the 10 minutes, as long as you don't. over abuse my last offer, Mr. Cannon.
I certainly won't, and thank you. I'm grateful for that. I'll probably finish within 10 minutes anyway. We're nearly there. These two, which the document says conditions requested by the objector, I don't think that's right. These are two conditions that we have put forward, and I just want to talk briefly about them. And in order to do that, I was going to just draw your attention, although I'm sure you're familiar with it, with section 18 of the Royal Borough's licensing policy, which is on page 78 of the bundle. Now, I don't want to take up time by going there, but just for your note, that's the bit that deals with shadow licenses. And what it says is the term shadow license describes a situation where a premises license is granted to one party, typically the freeholder, in respect of a premises where another party, the operator, already holds a separate license. Well, that's what's going on here, although we're not the freeholder, we're the head lessee, but nothing turns on that. And then it says the usual reason for this would be to protect the freeholder in case the license holder surrenders the license without giving the landlord any notice. For example, if the license lapses due to the death, insolvency or incapacity of the license holder, or if review proceedings are brought against the license and the license is revoked with the landlord not knowing this. So that's the policy saying, here's what we're doing. Now, number 26 says if the premises, like the main premises license, is revoked, so if they do something wrong, get a review and the decision is revocation, then what we're proposing is that this shadow license for which we're applying today won't come into effect until at least 30 days after that revocation, just to allow a period of cooling off. So if there's any suggestion that this might be an attempt to kind of get round a revocation, that's dealt with by paragraph proposed condition number 26. So there would be no activation of this license in a revocation situation for at least 30 days. And then 27 deals with the same point, that if the current license is revoked, so the UKAI license is revoked, Mr. Veros's, then the DPS, Mr. Veros, and the management team, that obviously changes from time to time, but at that time, by condition, would have no involvement thereafter. So again, I hope some reassurance that there's no suggestion here of an attempt to get round any future revocation. And then I just want to turn lastly to number 28, which has been suggested, I think, by the legal advisor. This premises license shall have no effect until such time as the existing premises license has been surrendered. I think that we've got no difficulty at all with the idea behind it, which is that only one of these licenses should be able to be operative at one time. My only difficulty is the word surrender, which has a particular meaning in the Licensing Act, which is a positive giving up of the license and doesn't cover, as it happens, death, insolvency, capacity. Those are examples of a license lapsing rather than being surrendered. So my suggestion is that condition is perfectly fine as long as instead of the word surrendered, we have a word that covers all of those situations, including death, incapacity, insolvency. And my proposal is until such time as the existing premises license for UKAI number ceases to have effect, which would cover all of those situations: revocation, incapacity, death, so on and so forth, and not just surrender. So those are that's what I want to say about the application. The fact that no responsible authorities are here has two ramifications. One is that you can feel comfortable that there isn't any particular issue about the licensing objectives raised by this application, unsurprisingly, because it mirrors exactly, and this is the second point, the present premises license for UKAI, which is conditioned by a detailed suite of conditions imposed by the subcommittee on the 13th of January 2021 following a review hearing in October, where the general operation of the premises, including the complaints that are in that schedule prior to that date, were all considered and dealt with. So if and insofar the question arises about impact on the licensing objectives, there's nothing in why we've applied to cause you any concern at all, perfectly sensible and for exactly the kind of reasons foreshadowed in your policy. There's nothing in any of the complaints, so unless you or your colleague have any questions for me, I think that's all I want to say about the application.
OK, thanks very much indeed, Mr. Cannon. I'll turn to Councillor Healy first of all to ask questions, and then I will have some as well.
Thank you, Chair. Good morning, Mr. Cannon.
Good morning.
Thank you very much. That was helpful. Could I start, please, with the complaints? You sought to reduce the number of complaints by saying there are only about 2 or 3 since the review last October. In fact, there are 7 since then. I accept that the table and chairs one was not a real problem, but most of the rest are about very specific issues of music and operating outside the licensing hours. Could you tell me where you think we are in terms of keeping to the conditions that were imposed last October?
Yes, of course. Forgive me, I don't want to take up time with these sorts of points, but the reason I don't think I said 2 or 3, but the reason I excluded the 5th of December 2020 complaint is because that comes before the decision on review. There was quite a long gap between the review itself and the decision, but nothing turns on that, and I accept it was after the review hearing itself that we didn't get the decision until the 13th of January. I just want to deal also, I should have dealt with this first of all, 24th of December 2020, a query stating that UKAI have been serving takeaway alcohol. Well, there's nothing unlawful about that at all. At the moment, as you know, all alcohol-led premises can sell alcohol for consumption off the premises. So I think there was a conversation then about that, but I don't think that's a legitimate complaint either. But you're quite right, there are then some complaints about loud music. I don't want to get into a factual dispute about this. Mr. Mervyn can give evidence if needs be. Our position is that none of those complaints were substantiated. And I think what I want to say about it is that if they were substantiated, if they were true, then we would have an objection here from your environmental health team, a representation. They would at the very least be here to say they don't seem to be sticking to the conditions imposed at the review. They're not here. And you can read into that, as we have, that the position is by and large a good one, a positive one. There is no doubt that the Thomases who live opposite are hyper vigilant about noise. Our explanation for their complaints are really of this kind. First of all, that often it's not UKAI. They're complaining about noise that doesn't come from UKAI. This is on the corner of Portobello Road, which is, as you know, quite a noisy road, especially at the moment with outdoor dining. So we don't think it comes from us. We certainly haven't had groups of 30 outside in April. That would have been a breach of the COVID regulations. We don't have the facilities for groups of 30, and you can see from the photograph that we have tables and chairs out there. You can't group 30 people together. And the complaint of loud music is puzzling to us because for all the times that those all of the loud music complaints, so there's one on the 30th of April and then one on the 17th of April, were at times when we couldn't have anybody inside the premises, and we're not allowed to play music outside the premises. So the idea that we were playing it inside to an empty restaurant doesn't make sense to us. So we think that might be from a different venue or mistaken identity or cars driving past or something, but we can't understand how it could really be us. And I think the fact that there's no environmental health representation today, no concerns expressed by environmental health, supports our view of that. So I hope that's a helpful answer.
Yes, that is helpful. However, I note that 3 of these cases, the 17th of April, 30th of April, and the 15th of May, are all still ongoing cases.
Yes, they are. If they were, I mean, I'm not sure what that really means, because presumably the noise stopped at some stage. I don't think there's going to be any further investigation. If there was a concern from environmental health, to whom I imagine those complaints were made, then no doubt we'd be hearing from those officers today. But yes, I note that we haven't heard anything about those complaints other than this schedule, and certainly doesn't seem to be any attempt to have investigated with us. I can only assume that environmental health are not concerned about them.
Thank you for that. You seem to be implying that Mr. Thomas and his family have a particular grudge against UKAI. Could you expand on that, please?
Not a grudge, but they certainly don't enjoy having UKAI next to them. They were the bringers of the review in October. And they are, as we understand it, the originator of all of these complaints. I don't suggest any grudge, but I do suggest that the relationship is not a good one. In fact, the review dealt almost entirely with allegations made by there are only two of them, I think, who live in that particular flat, and the answers given by UKAI, although there were other neighbours that made representations too, that was the key dispute. So certainly not suggesting any grudge, but they are clearly very concerned about the operation of UKAI, and in our view have made complaints as listed in these schedules, and as I've said, which are not about UKAI.
And what has UKAI done to try and mend this relationship?
Well, not a great deal since the review. There is only so much that one can do in terms of trying to make better relationship. The real answer is we've sought very hard to operate within our license terms and not to cause any nuisance, and we think we've done that properly. That's the first step. If we can operate in a way, well, I say we, if UKAI can operate in a way that is within its conditions and promotes the licensing objectives, then one hopes that our neighbours will, in time, feel less aggrieved about our presence on the street.
Okay, thank you very much.
Thanks, Councillor Healy. So just, Mr. Cannon, from me, where you left off on condition, I think it's 29.
Yeah.
If my understanding of that's correct, there cannot be any parallel operation of both licenses at the same time. Is that my understanding of that correct?
It is, and that's. Sorry, I can hear an echo now. I wonder if Councillor Healy still.
Yes.
There we are. The intention is that there be no parallel operation. My concern about proposed condition 28 is that it only at the moment, as drafted, only concerns surrender, which is a very particular kind of non-operation of a license. There are other ways in which a license can cease to have effect. So I'm seeking to give effect to exactly what you've just described. So yes.
Right, and yes, I understood the point you were making there about the wording, and it is 28, of course, my mistake. What would be the arrangements for holding a private party should this shadow license come into effect?
That's not something I've given any thought to. Do you mean what would be who would be which would be the license?
Well, if this license comes into effect at some point in the future, under the circumstances you've outlined,
yeah,
how would a private party be handled within the premises? So page 30, we have a little section called regulated entertainment for private use indoors. That's in exhibit 1.
Can I just get there?
Yes, please do.
Yeah, I'm there. Yeah, I have to say so. This is not something that's been raised with me before, and I haven't taken instructions on it. This is really just replicating, as I've already said a number of times, the conditions that are on the UKAI license. So that's obviously something that's there too. I think it's right to say that where you've got private parties of that kind, then the Licensing Act, at least arguably, has nothing to say about it. But I wonder if Mr. Mervyn would like to come in and say anything about that. It's not something that I've taken any instructions on or has been raised with us in the past, or indeed Mr. Lavelle might want to say something about it. But the best I can say is that it just mirrors what's permitted presently on the UKAI license, and I don't think there's been any issue with that. I don't know whether either of my colleagues are going to volunteer to jump in and help him.
Very happy to listen to what one of them might have to say.
This is Mr. Lavelle here. Simply stating, as we prepared and drafted this application, as it's a shadow license, it is designed, certainly in the first part, to simply replicate the existing license. I would suggest that if there was a specific issue with activities under an existing license, once members were considering the shadow license application that's correctly made in line with the existing license, maybe there would be a need to tweak or change what had been applied for. But I would suggest that would require very specific representation indicating that there was a problem with that activity. I don't know if that's helpful. I would just suggest that's how it would stand.
I think, as I understand the legal position, the current restriction on live music on the UKI license is something that was imposed by the review, or it might have been imposed before, but it's imposed. But it's not something that can exist unless it's specifically imposed, and therefore the shadow license can't have a restriction on music because there hasn't been a complaint under the shadow license yet.
Chair, it's Heidi Titcombe here. Would you like me just to come in there?
Ms. Titcombe, if you wouldn't mind explaining that point more articulately than me.
So there's two aspects, just going to the first point. Because this is a new grant, it has to be determined on its merits. And the applicants will be aware that we have a midnight policy, which is in paragraphs 813 of the Statement of Licensing Policy, which is on page 73. And it says that the committee, because this is a new grant, the committee would have to consider whether any operation beyond midnight should be granted. And the policy requires that any exception to the policy, it's up to the applicants to put submissions to you, and that may be something that Mr. Cannon and his team may want to comment further on as to why this should be granted as an exception to policy, because that policy now kicks in. In relation to the exemption, in fact, I would disagree that the exemption, the taking off of the exemption on the review would apply to this policy, because section 177A specifically says that a premises is entitled to benefit from the exemption in relation to live music and recorded music between the hours of 8 and 11, unless following a review of that license, the condition is imposed. Now, because this is a new license, unfortunately, condition 11 cannot apply because this is not a review. So there'd have to be a further review of the shadow license in order for this to bite. So this means that, in fact, the conditions that it is suggested will apply between 8 and 11 will not apply. So that will presumably affect conditions 8 and technically condition 14 on the license between the hours of 8 and 11. So I think that is something that it appears the parties have overlooked that. And I don't know whether that has affected the number of representations received, but it would be unlawful at this stage to impose that condition.
Thanks very much, Ms. Titcombe. Could I ask Mr. Cannon and your team to come back on that, please, and give
certainly. The first point is that in broad terms, as usual, Mr. Titcombe is right, but I'm afraid it's not right to say that it would be unlawful to impose that condition. It's perfectly lawful to impose it. The point is that the condition would have, in circumstances where the UKI license lapsed and this license had effect, that condition would have no effect. It wouldn't work. It wouldn't bite between 8 a.m. and 11 p.m. That's correct. That hadn't occurred to us, but having listened to what Mr. Titcombe says, that's right. It doesn't make the condition unlawful to impose, but it would mean that it would have no effect in that time. Two points. One is I don't think anyone's made a representation about this, so I'm slightly anxious about getting into the weeds of it. But the second point about it is that I think we could get round it by a condition that the premises license holder of this license, if you grant it, will abide by condition 11 of the UKI license, notwithstanding the provisions of the Live Music, or well, it's not actually the Live Music Act anymore, but 1771A, I think it is, but we'll get chapter and verse on that. So I think that's probably the point. I think it's highly unlikely that the parties, as Mr. Titcombe says, have overlooked it. I just don't think this was an issue that was of concern, but I think it can be got round if you've got any concern at all about live music between 8 a.m. and 11 p.m. By a condition in the terms that I've said. Forgive me for being slightly on the hoof about this. It's not something that's been raised before, so I'm trying to deal with it as best I can. But I think that would be the way around it. And I know that my client would have no difficulty with a condition of that nature, because the purpose here is to replicate the conditions that were imposed at the review.
Unfortunately, I appreciate what Mr. Cannon is saying, but unfortunately, from a legal point of view, Section 177A is quite clear. It's saying any condition on the licence relating to music, live music or recorded music, does not have any effect. Now, that is a statutory requirement, so it doesn't matter whether the applicants were willing to give an undertaking or whatever. The point is, if there were problems, the council would not be able to enforce that condition, so it would have no effect. And I don't think it's fair to say that there's been no representations, because as the applicants have quite fairly said, they've overlooked it, and they're the people making the application. And you've got two sets of lawyers, so there's professional advice here, so it's been overlooked. So you couldn't really expect lay people to understand the niceties of whether that condition could be on, because one could argue that all the people who looked at this, including the responsible authorities, assumed that that condition would be on, as has been suggested, which, you know, quite fairly, you've all assumed that it would be applicable, but unfortunately it's not applicable, and it would have no effect. And bearing in mind, it was placed on the licence very recently on the review in order to cater for the problems of public nuisance, which is a concern, was a concern then, and it's been raised again. That is an important factor for the committee to take into account.
Well, so just very briefly, I wasn't suggesting anything other than that there were no representations. And of course, Environmental Health, who are the statutory guardians of noise, haven't. And in the same way, I'm sure Ms. Tickham's right, they just didn't spot it, just like we didn't. But I wasn't really making reference to anything other than that. I have to say, I'm not really sure what's being proposed here. I think Ms. Tickham's analysis of the law in terms of whether that condition would in fact have any effect between 8 AM and 11 PM in circumstances where this licence were to have effect because the other one had ceased to have effect, I think is generally correct. But I'm not quite sure what is if anything, is being proposed. I think I've proposed a workaround. It may well be that Ms. Tickham's right. I suspect that the answer is that this is one of those situations where we have to just wait and see. And if a problem does arise as a result of what is, after all, national law about the regulation of live music between 8 AM and 11 PM, deregulating it, then a review could very quickly be brought and wouldn't be opposed by the licence holder, because we're perfectly happy, as I've said, to abide by condition 11 on the existing licence should we have to operate this licence. But I haven't yet heard a suggestion as to how we get round the issue that Ms. Tickham raises.
It does seem...
Sorry, with respect, it's not for me to suggest a way round it. I don't think you can get a way round it. But what I'm saying is the whole application is based on the fact will mirror what is on the existing licence, but they won't. That's the problem. And I mean, it's important because those conditions were put on very recently following a review with the agreement of the applicants. Unfortunately, the application cannot cover it. So I don't have a solution for you. Unfortunately, I can't get around the law.
No, that's helpful. So I think the solution is that unless you're concerned that this is the kind of issue that warrants a refusal of the application altogether, and I would say strongly that it isn't, then it's just something that we'll deal with in due course if it becomes a problem. I think Ms. Tickham's right that the law makes things a bit difficult here. The law seeks to deregulate live music, remove it from the purview of the licensing regime, unless there's been a review. There has been a review of UKAI's licence, which means that condition 11 is on there and bites. There hasn't been a review of this licence because it hasn't even been granted yet. I think if it becomes a problem, a review can deal with it, and that's what the law envisages. I take Ms Titcombe's point. As usual, she's right on the law, and it's a good spot, but I don't think it's the sort of problem, certainly I would say it's not the sort of problem that should lead you to refuse the application. I have to say it's not even solvable insofar as it needs solving by removing authorization for live music, because the other effect of the act is to make live music between those times not regulated entertainment, so you don't even need a license to put on live music. So I think Ms Titcombe's point is, if this license is granted, there would be, in a sense, the ability to offer live music come what may between 8 a.m. and 11 p.m, subject to the restrictions about amplified and numbers in the audience and so on and so forth. But I think accepting the correctness of the point, subject to that point about being unlawful to impose it, the answer is I don't think it's a problem. I think it's an identified lacuna, I suppose, but certainly no evidence at the moment that it prejudices the licensee objectives.
Okay, thank you. I don't think we'll get any further untangling that point just now, but can I draw you back to Ms Titcombe's first point on the midnight policy, please, and find out what your observations are on that, Mr Cannon, please.
Yes, of course. The answer to that is straightforward. The basis for the exception is that is the framework within. Very recently, the subcommittee agreed that this premises can operate, having regard both to the policy and also to the licensing objectives. So somebody's thought, to put it in sort of layman's terms, some of your colleagues at a subcommittee have considered in the last 8 months what the right hours of operation for these premises should be, well understanding what the policy says, and have decided that we should be allowed, or that UKAI should be allowed to operate a very little bit beyond the midnight suggestion in the policy, and nothing has changed. And I know in particular that none of the schedule of conditions suggest that the issue was particularly related to the period after midnight, and there's certainly no evidence of that. So I would say, if you're looking for evidence for a grant along the same lines as that which was granted in considered in October and granted in January, then that decision is the evidence for that. There's certainly nothing new since then.
Thank you very much. I'm grateful for that clarification, Mr Cannon. There's been quite a lot of occasions this morning during your submissions and the questions where you've been referring to what we do and what we should be allowed to, what we do at the moment. What is that line between the lessee and the operators of UKAI?
That's a fair point. And I think that's my own loose language. As you may know, I represented UKAI in the review, and I make no bones about this at all. Mr Mervyn is the director of Freshly Made Limited, who are the head lessee. They're a company and are a head lessee of the building, 240 Portobello Road. He sublets that to Mr Veros, who runs UKAI, but Mr Mervyn, with a keen interest in making sure that this is a success, is also involved in the running of the operation. He's not the designated premises supervisor, he's not the premises license holder, but he is, for perfectly sensible reasons, because he has a financial interest in it as the director of Freshly Made, involved. And in fact, Ms Titcombe will remember that he was present at the review and gave evidence, answered questions, and was there just as he is here today. So I make no bones about that. There's no hiding anything, and perhaps my slight loose use of language reflects that in effect there is a similarity here, but if or not a similarity, an overlap. The point that I'm making is that if the license for UKAI lapses by some fault, so not by incapacity, death, or whatever, which of course there would be no reason to have any concerns at all about this kind of thing if it was one of those unfortunate events, but if it was by some fault of the operation, then that's why proposed conditions 26 and 27 are suggested, which makes sure that nobody involved in the running of it will be involved. So no DPS, no premises license holder, and the management team will have no involvement directly or indirectly, and there'll be a 30-day cooling off period before the license can operate again, which would give the local authority, if it wished, an opportunity to discuss the position. So no secrets about the these are not arm's length, totally unconnected, absent freeholder and license holder. There is a connection, but for the reasons that I hope I've made clear, it's prudent for Freshly Made Limited, the head leaseholder, to protect itself in circumstances where it might find itself unable to beneficially use the property for what it's intended.
That is very helpful, but under that, what you've just said, Mr. Mervyn, who is the head lessee, would be excluding himself from running a new operation because he's currently involved in UKI.
Well, I don't think that's right. He's not the DPS, he's not the premises license holder, and at the moment I don't think he's part of the management team, but he is involved. But clearly, if there was a, and we're in a sense we're kind of casting our minds into the future in a hypothetical way. If there was a revocation, so proposed conditions 26 and 27, if there was a revocation, that's what the 30-day time limit seeks to produce. If there was a revocation, and if the local authority or anybody were concerned that Mr. Mervyn was the problem, as it were, then there would be time in those 30 days to resolve that issue. I think that's highly unlikely to come to pass, but if it did, looking at worst cases as lawyers often do, that's why that 30-day cooling off period has been imposed, to give an opportunity for representations to be made, or a review brought actually in respect of Mr. Mervyn.
Right. I don't know if anybody else has got any questions for you, Mr. Cannon. Just go back to Councillor Healy to see if she's got anything she wishes to raise.
No, thank you, Chair.
Ms. Tipcombe, do you have any other points that you want to put to Mr. Cannon? I do have a question for licensing, but we'll hold that for a moment.
Yes, just in relation to that condition that Mr. Cannon has suggested, the conditions 26 and 27 on the objection sheet. I don't know if they could be put up on the screen, if at all possible.
There we are.
I'm just wondering what the purpose of the 30 days is, because even so just following on from what you were just saying a moment ago, say for example there was a problem with the license, whilst there's a cooling off period, or even if a review is brought, it wouldn't prevent that license coming into effect. And if Mr. Mervyn, if the objectors thought that Mr. Mervyn was connected to the previous operator, he'd still be able to, according to what you say, he'd still be able to be involved in the new license. And even if a review was issued, that review process would take 2 months to sort out. And then if you appeal it, which is probably highly likely, then it wouldn't be determined until the hearing before the magistrates' court. So the problem, and I understand it's a good idea, but I'm just wondering in practice what comfort it really would give to the committee, because after 30 days you could still run your license, and if there were problems you would still have to go through the whole process of a review, which doesn't happen overnight. And because that decision of a review won't come into effect until either 21 days after that decision, or if there's an appeal after the appeal has been disposed of, that can be a very long, drawn out time for people to be experiencing problems.
I can try and answer that, which is in this way. First of all, the whole point of this is to deal with a range of circumstances in which the present license to operate UKI ceases to have effect, and the majority of those are non-fault, non-controversial ways: death, incapacity, insolvency, surrender, and so on. And in none of those circumstances would there be any concern at all about this, or should there be any concern at all about this shadow license having effect. So in a sense, the majority of circumstances which we're trying to cover, this doesn't arise. What we're talking about here is the relatively narrow potential situation in the future, where not only is there a fault-based reason for the ending of the UKI license, but that the fault lies at the door sufficiently seriously to warrant his exclusion of Mr. Mervyn, who is neither the designated premises supervisor, the premises licence holder, or part of the management team presently, although he is, as I've said, involved. He advises them on various issues and helps them out with certain things. In those circumstances, the 30-day period is in order to allow a review to be brought. Now, I accept entirely that in those circumstances, which is a pretty narrow set of circumstances, which we hope will never arise, no reason to think it would, the 30 days would allow a review to be brought and the concern to be expressed. Now, again, Ms. Titcombe's right that if, I suppose, again, putting it colloquially, Mr. Mervyn wanted to play hardball, he could wait 30 days and then start operating. But I dare say that would count quite significantly against any appeal that was brought on the basis that he shouldn't be excluded, the fact that he'd sought to get around it. So I think this is, again, one of those problems that probably could, if a series of interrelated ifs became whens, it might arise. But in such circumstances, I think there would be power to do something about it. Again, I'm not sure there's a solution, because you certainly can't you couldn't reasonably extend the cooling off period to cover not only the bringing of a review, but also however long it took to get to the end of an appeal period, because one doesn't know how long that is, and it's often extremely long. If you thought it was, I mean, I suppose there's no magic in 30 days. That was thought to be a sufficient amount of time in order for concerns to be raised. And the last thing I should say is that there is a good record, and this brings me back to something that Councillor Healy raised a moment ago, and which I've had instructions on since. There's a good record of Mr. Mervyn in particular having good interactions and communications with officers of the council. He has always sought to engage with the council. The 30 days also allows, before we get to formal reviews and so on, it allows a conversation to be had. And I would say on his behalf that the first port of call in a situation like that would be a phone call from the licensing officer to say, listen, Mr. Mervyn, you've been at fault here. You're the fault of this revocation. Shouldn't you be excluding yourself? And I don't know, we're speculating completely, but it allows for that too. Just very briefly on the point that Councillor Healy raised earlier about what efforts have been made to mend the relationship, I'm told that a question was asked of Mr. Mahaffey, who's the Environmental Health Officer, by I think by Mr. Mervyn actually, about whether it would be sensible yet to approach Mr. and Mrs. Thomas to try and see if a dialogue could be started, and was advised by Mr. Mahaffey that it was too soon and it wouldn't be the right time yet. I'm told that Mr. Mervyn will continue to monitor that, and if the time is right in Mr. Mahaffey's view, then he's more than happy to meet with them. But that was just an amplification of the answer that I gave, slightly imperfect answer I gave to Councillor Healy a few moments ago.
Thank you, that's helpful. Just going back to the question that you'd raised, Chair, about the unrestricted hours, and Mr. Cannon quite fairly said that this is being considered a review, so he thought that the unrestricted hours should apply. However, when the review was considered, the committee at that time had the unrestricted hours, but then the premises were didn't get the benefit of the music exemption. Now, in this case, there is no benefit. So music can be allowed during 8 to 11 p.m, as we've already discussed. So it's different. So the committee could say, well, they don't consider it is appropriate to have the unrestricted hours. It's not something that would normally be granted on a new licence. So it is within the committee's powers to, if they are concerned about this, it's totally within their remit to decide whether it's appropriate to have on or not, especially as because of the legal restrictions. It's not because of anything that we're doing here today. The exemption would still apply.
So can I just respond to that, because I think that's not quite right, if I may say so. The non-applicability of conditions about music only apply between 8 a.m. and 11 p.m. So if we're talking about what Ms Titcombe calls the unrestricted hours, and that's the point that Sir you raised about private parties, then the unrestricted nature of that would not be as to hours, because that would only apply between 8 a.m. and 11 p.m. After 11 p.m, the deregulation of music doesn't apply anyway. So in effect, you would only be talking about the non-applicability of conditions about music insofar as it was played between 8 a.m. and 11 p.m. So I don't think that's a problem that actually arises in practice. I've just had brought to my attention by Mr. Lavelle, and of course he's quite right, that just going back to conditions 26 and 27, I think this is an important point in reference to Ms Titcombe's last point, where it says in the event that the current licence is revoked through a review in each case. Of course, as a matter of law, the licence is not revoked until the expiry of the appeal period. So the decision of a subcommittee, in fact, doesn't take effect. So it wouldn't be this licence, this proposed shadow licence, that would have effect. In fact, UKAI's licence could, in theory, as with any review, continue to operate pending the appeal period. So I don't think actually, and I'm not being critical of Ms Titcombe, we're dealing with this on the hoof, but I don't think the issue that she raised would apply here, because the 30 days would only kick in after the appeal period finishing or the appeal having been decided. So it's only in those circumstances that we'd be talking about it.
Understood.
I'm not sure I entirely agree with that, but I've noted Mr. Cannon's submission.
And we'll come back to the conditions very soon. I do want to ask the licensing officer, Mr. Phelan, for your comments on the complaints, please. Particularly the 17th of April, 30th of April, and well, those are the two, and perhaps 15th of May as well.
Well, certainly, Chair. Just pulling the conditions, the complaints up now. Okay. In terms of comments, Chair, there's not really much for me to say, only that these complaints were obviously received from residents. In terms of what the outcomes are, the cases remain open so that if further complaints are received, we can log them to an appropriate case. So essentially, just as it says, wherever it says that a case remains open, it's purely for the administrative purposes of logging further complaints. There's not really a comment that I would have to say on them, other than that they have been received and they have been included in the schedule before you.
And there's no more detail that you can add from your knowledge in the licensing team beyond what's written here in the... No, unfortunately I wouldn't be able to, Chair. As I say, it's a very brief summary of the complaint. Just if there is no a conclusion to what happened, then it's possible that it may be ongoing. But as I say, if a case remains open, it's not an indication that it remains open due to action. It's more that it's there in case there are further complaints, so that we have an accurate register of all complaints received. Okay, thanks very much, Mr. Phelan, for that. So I think the next stage, if we could go back to the beginning of the conditions, please, and I'll invite Ms. Titcombe to go through them in some detail. And I think I'd certainly have one or two questions about conditions, which I've been holding off until we get to this stage. Obviously, I'll put up front that the condition, this discussion does not prejudice the committee's first decision as whether to refuse or grant. So this is a conditional discussion about the conditions.
Thank you, Chair. I wonder if it'd be possible to put the conditions up on the screen. The conditions list, sorry. Whilst we're waiting there, the condition 7, I mean, I appreciate the applicants have tried to replicate the conditions on the existing licence, but condition 7, little 1, is of nil effect. And that's because that condition applied to the first floor, which is no longer part of this licence. So I just wanted Mr. Cannon's view as to whether that actually should be deleted.
I think it's fair to say we haven't tried to. Sorry, I'll put my camera on. It's not that we've tried to replicate the conditions. We have replicated them precisely from the other license. I think there is no first floor, and that's true. But I don't see any difficulty with that condition being on the license. The fact that it has nil effect is neither at the moment is neither here nor there. If in future there was, I don't understand there to be any, but if there was a plan to use the first floor, then the condition would apply to it. I don't see there's a particular problem with it being on there just because there isn't a first floor at the moment.
Okay, that's fine. And then just moving on to condition 10, about which is your challenge 25, well, challenge 20. I mean, did you have any views? I mean, that was challenge 20 because this has probably been put on years ago. Did you have any view as to whether that should really be updated to a challenge 25?
No view, but there's absolutely no suggestion ever of any sales to underage people. So I'm not sure there's any merit in doing that. I understand that in some places challenge 25 is the current sort of standard policy, but I think really if you're going to change conditions, that was imposed without caveat in January 2021 or reimposed, wasn't looked at in the review. I can't see that there's any particular reason to change it, although at the same time I can't imagine, other than having to change the operating procedures and training, I can't imagine there'd be any strong objection to changing it. But I just don't think there's any evidence at all that there's an underage drinking issue. In fact, there isn't at UKAI, and there's certainly no evidence of it. So again, I think this might be an issue without a problem, as it were.
So I mean, the reason I'm looking at these conditions is because I'm looking at our policy, which says that conditions should be updated, especially old conditions, and that's a specific policy that has been put on our new policy that came into force on the 7th of January this year. So it's a new policy. So that's why I'm looking at that condition. So if the committee wanted to update it with the challenge 25 standard condition, is that something you'd be agreeable to?
As I've said already, no difficulty with doing so, but let's just remember that challenging everybody who appears to be under 20 seems to have worked fine for the last 10 years or however long it's been, but no objection. If the committee think that that's the right thing to do at this application, then there's no difficulty with that.
Thank you. And then in relation to the condition 13, the dispersal, there's a proposal to put a dispersal and external management plan in place, but there's no period as to when it should be put in place. So could we alter that wording to say before the premises can operate under this licence, a dispersal policy shall be put in place? That's condition 13.
Yeah, that's on the screen. Again, I've no particular difficulty with that, and I'm sure my clients will. I think we just need to remember that this is not a licence that's going to have effect on grant. This is a licence that's going to sit in the background until a time when something else happens. So talking about timing might be a bit tricky. My one caveat about the suggestion that's being made is that if one of those, let's say, and heaven forfend, but Mr. Veros becomes incapacitated and the licence lapses, a requirement that there then be a dispersal and external management plan be submitted and approved before the licence can have effect seems onerous. It may be that we could simply discharge this condition by using the dispersal and external management plan that UKAI, Mr. Veros's licence, presently uses. But again, that condition requires a plan, and if the plan doesn't exist, then there would be a breach of that condition. I think that probably deals with the point. I think putting timings in circumstances when we don't know if this license will ever have effect, and if it does, we don't know when or in what circumstances, is probably going to cause more difficulties than it solves.
I hear what you say, but the problem with this is that it doesn't have any timing, and that would potentially be an error in that condition, which may have not been noticed at the time. Because if you go down to the last paragraph, it says once the revised plan has been finalised, the premises licence holders shall implement it. So there'll be no requirement to actually implement it until they've actually submitted it. And because the first part of it doesn't say when it needs to be submitted, that's why I'm suggesting that it's not onerous. It's a matter of correctness, that you should put in a requirement as to when it should be submitted. And bearing in mind that your client's not going to be using it, that they could put it in a month before or a day before. And bearing in mind you've got the 30-day cooling off period anyway, would that really be a problem?
Again, I think we're talking about issues without problems here, but I've taken instructions and we're more than happy for some wording to be added. The suggestion that's made is that the words "before this license is used as an authorization for licensable activity, comma, a dispersal and external management plan shall be submitted," which I think will deal with the issue.
Sorry, can you just repeat that?
Yeah.
Yeah.
Before this license is used as an authorization for licensable activities, comma, and then the rest of the condition.
Okay, thank you. And then I've already explained that I don't think that condition 14 will be restricted between 8 and 11 because that will be exempted. In terms of,
was taken before you go on beyond 14 and
yep.
Just 8, 11 and 14 together. Are you, just to clarify this, are you saying that they will apply after 11 p.m? Well, they would be able to apply after 11 p.m, just not before?
Yes, that's right.
Right.
Sorry, Jim, can I just raise a point on condition 13?
Yes.
Since this already applies to the current licence, has the plan not been produced already?
Perhaps Mr. Phelan could.
Well, I can help with that. It does apply to the licence, and my understanding is that there is a plan, but of course that's a plan that, in the sense of intellectual property, belongs to the present licence. Now, as I said, in order to comply with it, it may well be that we being Freshly Made Limited take the contents of that plan and submit it as the plan for this licence if you're prepared to grant it. So I think the plan exists. At the moment, it doesn't have Freshly Made Limited at the top. That's the point.
Does that cover it, Councillor Healy? Okay, thank you. So as Councillor Hammond has said, the exemption would apply to 8, 11 and 14, would not apply to 8, 11, 14 and between the hours of 8 and 11 p.m. And the only other questions I've got are in relation to condition 28. Mr. Cannon suggested some revised wording. Could you go through them, because I didn't manage to get your wording down at the time. So sorry, you're on mute.
If the person on the screen could just go back to condition 28. There we go. My suggestion was that instead of the words "been surrendered" at the end, which I said are too narrow, only cover a very narrow way in which the licence can cease to have effect, if instead it says "has ceased to have effect," full stop, which covers, I think, loss by death, incapacity, insolvency, also surrender, also revocation.
Okay, thank you. That's all the questions I've got in relation to conditions, but I think Councillor Hammond may have a few more.
I don't actually, because we covered them during the examination in detail there. Okay. Unless Councillor Healy's got anything else she wants to bring up as her hand's up, but that might be an old hand.
So might I?
The hand up, but no, I don't have any further questions. Sorry,
No, that's all right. I think we've met that cap before, Councillor Healy, in another hearing. Obviously enjoys licensing. So
indeed,
just to clarify an answer that I gave earlier, I've just had some instructions. As you can probably tell, I'm in touch with, although I'm at my home, I'm in touch with my team by other means. And there was a question that I think you asked to Mr. Phelan about those complaints. I'm told that as well as those complaints, there have also been a number of visits by Environmental Health since the review, and none of them have raised any problems. If you want to hear a bit more about that, then Mr. Lavelle can help you with that. But it ought to just complete the picture that there have been some visits from Environmental Health rather than licensing, just to check on how things are running. So again, part of the picture since the review.
Okay, thanks, Mr. Cannon. I personally don't need to hear any more from your party about that subject. I think we've taken it as far as we can. Councillor Healy, your hand is still up. Is that an old hand?
It's an old hand.
Oh,
I
sorry.
can't get
Yes.
it down. Sorry.
You can't get it. No problem at all. Right. Okay. That concludes everything, unless legal officer's got anything more to say, Mr. Titcombe.
Nothing further from me, Chair. Thank you.
Anything else from the licensing officer, Mr. Phelan?
Nothing from me. Thank you, Chair.
Okay, we don't do summing up, and we're not reconvening to hand down at the moment, as you're probably aware, Mr. Cannon. So governance will notify the parties of the decision within 5 clear working days of today. That'll be the summary decision, and then the full determination will follow in due course. So that's the hearing at an end. Grateful for all the representations this morning, and wish you all a good day and good rest of the weekend. And the broadcast will now end. Thank you all very much.
Thank you, sir.